Thank you. We'll now call the case of Cook Martin Poulson versus Smith, our case number 2023-0024, and take appearances from counsel.
Troy Boer, Taylor Webb, and Russ Walker for the appellant.
Thank you.
Thomas Burns and Aaron Harris for the appellee.
Thank you. Looks like you've reserved 5 minutes. And unless you have questions about how we do this, we'll go ahead and proceed.
Thank you, Your Honor. May it please the court. I want to begin with the exclusion of the declaration. And even though we've argued that you shouldn't have to disclose yourself if you're a party, I don't think the court really needs to address that. There might be a hypothetical where that's true, because I think the harmlessness is, in my view, overwhelming here. This is a case where—
Well, the other side identified him as a witness, right?
Yeah, and he was identified as a witness in the consolidated cases. He submitted 5 declarations. There was an initial disclosure in this case. It was untimely, but there was an initial disclosure, and it was actually filed more than 3 years before the motion to strike the declaration. 2 different hearings where Dan was examined by opposing counsel. And so we think that if this doesn't qualify as harmlessness, then it is almost adopting a practical per se rule in the other direction, because there is no articulated harmlessness.
Yeah,
the court didn't find any.
In your brief, it seemed like at times you were asking us for a pro se rule in the other direction, that it's always harmless. And are you asking for that today, or just that it's harmless on these facts?
I'm not waiving that, but I will say that if I were in your shoes, I think because there could be hypotheticals lurking out there that would make you regret that opinion. I don't think it's this case. That I think the purpose of harmlessness in the rule, that this is the poster child case for it, I think that's probably the more responsible way to take care of it, as far as it putting in an opinion that's going to be cited by district courts and followed by district courts. I think that's the better way to handle it.
Yeah, especially given the standard of review. If we go around saying that something was an abuse of discretion in the harmlessness context, that sets a floor for trial judges. That really, that's a big deal. And that's why I think you've seen some caution from us in doing that in other cases. But that's what you're asking us to do today, to say that would be an abuse of discretion in this case, where the court determined it wasn't harmless.
Yeah, and honestly, Your Honor, if you look at the ruling, there wasn't really an exercise of discretion. There's just one sentence that says, by the way, I find that this wasn't harmless and there was no good cause. There's no analysis that's done. And it's hard to see how there could have been, because there was no prejudice that was articulated. So I think that this has to be a floor.
And if his testimony or declarations come in, which are the key, or which are the material facts that then become at issue?
Yeah, I think at that point, we've got a declaration that establishes a breach of the employment agreement in 2013, because the correct amount was not paid that was provided for in the employment agreement. And just to be clear, Dan believes that the employment agreement is null and void, but for purposes of summary judgment, the court found that it wasn't, and the court found that it was breached. Okay. Dan's declaration would establish at least a disputed issue of fact. I don't think it would be very disputed, though, that he wasn't paid what was specified in the employment agreement in 2013. The only breach articulated in the argument section of the summary judgment was a breach in 2014. So you would have Dan articulating the first breach of the employment agreement, and a material one. You would also have Dan's testimony in the declaration that would establish a breach of the shareholder agreement in 2013, because the overall compensation was not, as it had been for every single year leading up to 2013, through the course of performance of CMB, that the overall compensation, including payments for insurance and spouses' salaries, like you name it, was not made on a pro rata basis. And that was a breach in 2013, which would predate any breach articulated in the argument section of the summary judgment. So he would have a way to get out of both of those because there would be disputed issues of fact.
So if we were to agree with you on the declaration and say the declarations, plural, should have been considered, what remedy are you asking for? Does that need to be sent back for the trial court to then reassess the summary judgment in the first instance? Or are you asking for some other kind of remedy from us here?
You could. I mean, I think there are two available options at that point. You could reverse the exclusion of the declaration, and you could say the trial court clearly based its ruling on summary judgment on the exclusion of the declaration, and therefore we're sending it back down to reassess it. I think that you have another option in this case, though, because review of summary judgment rulings are de novo, that I think you could look and say that, well, here's an articulation of a breach in 2013, here's an articulation of a breach in 2013 of the other agreement. Those predate any of the others, therefore there's at least disputed issues of fact, so we're vacating summary judgment. I think either one would be available, but you could certainly do the first.
I have a question under the employment agreement, even if we allow the declarations and the spreadsheet. The employment agreement says that he shall be paid $62,400 on an annual basis, and then $1,500 a month or $18,000 on an annual basis for not engaging in unauthorized competition. When you look at the spreadsheet, if the only line we look at is salary shareholder, that is 48,000, health insurance and contract, would that not also figure into that amount? Because the paragraph in the employment agreement does not use the word salary. It says compensation for services. Would the health insurance not be compensation for services?
For purposes of this shareholder agreement?
Of the employment agreement.
Well, for purpose of the employment agreement, which sets compensation for services, the sum of $5,200 per month, $62,400 on an annual basis as compensation. I mean, I think you can't read that as a matter of law to say that it's talking about anything other than just a dollar amount that's going to be cash or a check. I think maybe there is some ambiguity there when you read it with the shareholder agreement, which seems to include a lot more. But here we've got Dan's declaration that says, this says is the amount I'm going to be paid under this employment agreement. This is the amount that I was paid, and therefore there was a prior breach. So I think on
We
this
really can
record-
only look at the salary line.
I think so, yeah. I think I think the interaction between those agreements is a mystery. It's certainly been part of this litigation. I don't think you need to reach it to resolve this appeal, but I just want to flag that there are all kinds of answers to those questions lurking. So turning to the sanction, we've found no case in the country that says that you don't have to join in relief when it's requested, at least join in it in the district court in order to be entitled to it. Certainly in the sanction context, if you don't join in the motion for the sanction, then the sanction doesn't apply to you as a party. And we think that's true, and if you think about what the right remedy is here, I think short circuit what the argument is going to be from the other side in this way. Let's assume that this was a summary judgment rather than a sanction. You have two defendants, identical claims against both. One moves for summary judgment and the other doesn't join, and the other doesn't move. But the court grants summary judgment as to both. That's reversible error under the case law that we've found all across the country. You have to ask for the relief to be entitled to it. You may have to do a me too. It may be foolish not to do it. That's reversible error, but if you were on appeal, that might be kind of a sticky issue in your mind if you're an appellate judge, because you're thinking, well, what am I going to do? I'm going to vacate and remand and say, okay, now file me too, and then we win and we're right back where we are on appeal, okay? But that's because the merits themselves have been adjudicated, not a sanction. That's because the merits turned out a certain way. When we're talking about sanctions, it's different. And everyone recognized it was different for the first appeal. And you can see that because they went ahead and put findings before the court who signed them, and then those findings operated on the other claims. That's exactly what did not happen on remand in this case. So we don't have findings as a sanction. All we have is an order striking the counterclaims with regard to CMP. And then the court goes on to say, I'm also going to strike all of the claims against the individual shareholders, even though they didn't move for the sanctions, they weren't part of the briefing. I'm just going to go ahead and add them on. We can't find any case that makes that appropriate, and it doesn't
In
just
terms of
require-
looking at the language of our rule, is it the word it's by motion, that we would hang that on in terms of interpreting the rule if we didn't have the case law to look at?
I think that too. I think that bolsters it. I think that's why that's there. I think there are certain sua sponte sanctions that courts can impose, but this isn't one of them, and that isn't the way that it worked, and you need to follow the rule. So I think the rule contemplates that, and I think generally with practice, the moving party is the only one that's entitled to relief under the motion. And so this isn't like a merits adjudication, this is a sanction. And so it's a sanction striking pleadings to the extent they're directed at CMP. And we think it can't be a sanction striking pleadings directed at anyone else who didn't file the motion. And so it's inappropriate to include those as part of the sanction as a matter of law. And we think all of those claims against anyone but CMP should be reinstated for that reason. So they can be adjudicated on the merits.
I have a question regarding the shareholder agreement and the distinction between, and whether there is a distinction between distributions and salaries, whether distributions include salaries. Seems like if we were to interpret the shareholder agreement as you're suggesting, that it wouldn't matter if a shareholder is working, doing accounting work for the company, the company would be required to give every shareholder the same total package compensation regardless of employment status. Do you agree that that's what your interpretation would require?
Well, my interpretation, that you've just articulated exactly what CMP did every single year leading up to.
Were there any years when there were partners who didn't work as employees?
No, but they certainly didn't produce the exact same levels. And nonetheless, everyone was compensated pro rata based upon the cost of their insurance, based upon their salaries, based upon anything that counts as compensation. And there is support for this in 2.05 in the shareholders agreement. The pro rata provision says dividends and other forms of distributions from the company, and then it has parens, whether involving shares, cash, or other property, shall be made pro rata. And so it does require some interpretation of what that means and what's included. But when Dan's declaration comes in, you can see that there's a course of performance that definitively resolves that in the direction of pro rata applies to everything, including salaries. And so we think there's at least a question that needs to be resolved on remand with regard to that. I don't think the court should resolve that. I think that what the court should say, that it can't say as a matter of law on this record, given that course of performance, that salaries are not part of what needs to be distributed pro rata.
If we were to hold, for example, that because 2.06 does not talk about pro rata when it is talking solely about salary, I know this is not what you're arguing for, but if we were to say that the language plainly says salary does not need to be pro rata, does course of performance come in and trump plain language? Or if we say the language is plain, meaning X, then we don't even look at course of performance?
I think course of performance is more powerful than parole evidence and extrinsic evidence to some extent. I mean, I think
But
those.
isn't it
Course
by
performance-
definition
it's-
parole
Course
evidence?
performance is parole evidence.
It is a type, but I think I should say it's more powerful than ordinary parole evidence of what did we intend. So there can even be amendments of contracts through a course of performance. If it said 14 widgets, but you sent 20 for 30 years in a row and no one objected, and then all of a sudden you went to 14, the course of performance could come into play even though that number couldn't be any less ambiguous. So I don't think you necessarily have to get an ambiguity, but I think if you look at the shareholders agreement as a whole, it's hardly clear that they needed to put the words pro rata in 2.06 if the language in 2.05 is broad enough to encompass it. And it looks like the company thought it was broad enough to encompass it through their performance over the years. And so I just think the court shouldn't resolve that because I don't think it can be resolved on summary judgment as a matter of law. And I think once the declaration comes in, there's a question of fact there to be resolved on the scope of 2.05, whether it encompasses 2.06, particularly in light of performance. So I'm out of time. I don't want to forego the last argument on the repurchasing of the shares. If you'd just give me 2 minutes, I would be happy to do it very, very quickly. I just want to point out.
I think we're okay with 2 minutes, and we'll let them have 2 minutes as well.
Totally fair.
Because I am curious about what you have to say on that.
Yeah,
issue.
so I think that we do want clarification, once this is down on remand, as to who Dan should sign over the shares to consistent with the law. And certainly whatever this court puts in its order, he'll comply with. If the court thinks it can be signed over to CMP because his interpretation statutes is wrong, fine. If it needs to be another shareholder, fine, he'll do it, but clarify that. But that's separate from the reversal issue. The reversal issue is that if you look at their summary judgment motion, they did not request this relief to be declared that the shares had already been repurchased.
And here's my question on that. How was that not tried by the consent of the parties? Because we have case law saying that it can be tried at summary judgment by consent of the parties.
Because they didn't request it in their summary judgment. They didn't request the relief in the summary judgment, so they couldn't have tried it in the summary judgment by not requesting that as relief in the summary judgment. The first time it shows up is in the ruling that's drafted for the court, I should say the order that's drafted for the court, which is why we then opposed it in a post-trial motion. And just to be clear, we're not saying that they hadn't put in their pleadings and intended to argue that they triggered the repurchase clause and they intended to repurchase and the court should order that it happen. That's true. The question is whether they have to pay for the shares. And it's one thing to say that we've triggered the clause, now you're going to need to pay, we're going to need to pay you for the shares and you're going to have to transfer it over pursuant to the shareholder agreement. They absolutely pled that and we had notice of it and it's part of the lawsuit. But what is different is to say the transfer has already occurred and we didn't owe you any money for it. That can't possibly be. There is an ambiguity as to when you determine the clients that you can't work for.
Is there any dispute about that if you move the date one way or another, that then there becomes a disputed fact as to whether he worked for a client of the company?
Yeah, I think that's really important actually, because if you look at the shareholder agreement, what it says is that we're going to pay, well, first of all, we're going to send you a letter, which happens in December of 14. We're going to send you a letter exercising the option, okay? At that point, the very next month for a calendar year is what we're going to use to determine the price. And then the very next month, the 13th month, is when we're going to start paying you installments. And then it says that you can forfeit the right to those payments, right? If you work for a client on a client list generated at the date of purchase.
It doesn't say that that the list had to be generated on the date of purchase.
I think that is the language. Let me pull it up because I want to be absolutely precise on this. I don't want to tell you something that's not true. It says the client list, oh, you're right, not generated, determined. The client list will be determined as of the date of the sale.
So it seems like you could generate the list at any time, but you just need to know on
That's
the
right.
date, who were the clients on the date of sale?
Correct.
And do we have a dispute that if we move that date of sale one way or the other, that the client list changes dramatically vis-à-vis who he was doing work for?
I think we absolutely do.
Where
And
would we
here's
find that
why.
dispute in the record?
Here's why. Because it would be, well, there's a dispute about what the date is. They think the date is December of 14. We think the date is sometime later. We think exercising an option is not the same thing as the sale.
Do you have a
It's-
specific date that you think it is, or just it was sometime later?
We've put specific dates in our papers, absolutely, but let me make your work a little bit easier, because let's assume that it's December 2014, which is the earliest date it could possibly be, right? Dan is terminated in July of 2014. There are TRO and preliminary injunction proceedings, right, that find that Dan breached the covenant to non-compete and not solicit as of July of 2014 because he stole all these clients from CMP, okay? So we need to know which clients were left as of December 2014 on their theory of the date. Let's just take their theory. The earliest it could possibly be is 6 months later. 6 months later, what clients were left at CMP and which ones had he already solicited and taken, and therefore, according to them and the district court, breached the covenant not to compete. We don't have a list of what customers were left at that point, and we certainly don't have evidence of what that list was and that Dan worked for one of those individual clients. So it's not that
So it
they
sounds like it's
can't-
not so much a problem of who were the clients between December 14th and the later date. It's a question of who was left by the time you get to December 14th.
It
Is
might
that-
be on remand, Your Honor, because the dates, the client list is still gonna change during those dates. So if we're right, it's an even later date for the date of the sale, then it could be not a breach, but it would be if it's an earlier date. I mean, it could still matter, but even if you take it at the earlier date, you still need a list generated of what clients were left that hadn't already left with Dan by December. And it's not in the summary judgment paper, so they're just not entitled to win as a matter of law. Thank you. Your
Thank
Honor.
you.
Good morning, Your Honors. May it please the court, counsel. Interesting colloquy between the court and Mr. Boer in terms of many of these things, some of which I had intended to discuss today, some of which I had not, but I'm more than happy to address some of the issues. To the point, Judge Luthi, that you were discussing whether or not there was a trial by consent, I would ask the court to look at paragraph 15 of our motion for summary judgment, where the issue was squarely placed before the trial court. That also was seeking relief of our cause of action number 3, which was the breach of contract related to our election to repurchase the shares and our determination that Mr. Smith had failed to abide by the non-compete agreement, which by April of 2015 became very clear, because at the hearing for the TRO in April of 2015, counsel for Mr. Smith provided a list of clients that Mr. Smith was continuing to work with at that time. That list of clients was used to calculate the damages that had been suffered by CMP that resulted in the judgment eventually. So to suggest that there was no list at the time that Mr. Smith's shares had been deemed paid in full is simply inaccurate.
That sounds like, though, that was a list of who he was doing work for.
A list of people he was doing work for who were CMP clients, who had been CMP clients prior to his being terminated.
But don't we need to know who the CMP clients were in December? That maybe they were clients of CMP in April, but if by December they were no longer CMP clients, then it doesn't trigger the alternative price 3 under 7.03. Is that not correct?
Your Honor, I certainly understand your argument. I don't think that that is entirely accurate within the plain language of the entirety of the provisions related to the non-compete and how those calculations are made. But assuming for the sake of this discussion that that's the case, that might affect the judgment amount, but it wouldn't affect the question that Your Honor had posed as to whether or not there was some trial, or this issue had been tried by consent or addressed by consent of the parties in the summary judgment motion. My particular point was more directed at making clear that there was a list of clients that Mr. Smith had provided, clients who had been CMP clients, who he had poached in violation of the agreement. So there was a list at the time, which in and of itself, whether or not there may have been some error related to it, that error wasn't raised at the time of the summary judgment motion. And the trial court was entitled to rely on those numbers because they weren't contested at the time. So to suggest that that wasn't something that had been addressed, I think, is inaccurate. It was presented squarely in our summary judgment motion. Allegations, factual allegations, and arguments were presented, and that list was something that Mr. Smith had provided. So all of that was something that had been presented to the court for the court to rely on in making that determination on summary judgment.
I have a follow-up question, and it's probably just that I'm trying to get my head around it. What is the termination date that you would, what date would you give for termination for purposes of 7.03?
Of Mr. Smith or of 703?
Of Mr. Smith.
Mr. Smith was terminated on July 31st, 2014.
And you're right. And so what date would be operative under 703?
I believe that would be the date, Your Honor.
Would
His
be the-
termination occurred that day. He was alerted of his obligation to comply with non-compete soon, or within the letter, soon thereafter, and then in December, a final notice that if he continued to do so,
So you're saying it's not the December date, that it's the
His termination date,
His
yes.
termination date is the date that we look to for 7.03.
Yes, Your Honor, and I
And
think,
that as of that date, it is undisputed that he was doing work for CMP clients,
yes, Your
if a
Honor.
list were to be generated as of that April date.
As of that April date, the clients who existed on that date, he provided a list to CMP in April of 2014 of the clients for whom he was providing work at that time. I don't have it in front of me, Your Honor, but I don't recall whether or not there are dates when those clients moved to his business. I'm not certain that that's on that list. I think it's a relatively complete list that my client used to calculate the amount of damages that they suffered as a result of those clients migrating from July 31st, 2014 forward to that point in time, Your Honor. Does that help?
Yes, thank you.
Now, I believe that where we started was on what may be a hot button issue, and that is the application of 26D4 in terms of sanctions. There are two issues that were raised in the briefing, and one is the, not 26D4, but that's importantly, in terms of summary judgment, 26D4 was applied by the court in relation to Mr. Smith's ability to testify in opposition to the summary judgment motion. Now, the reality here is by that point in time, we were talking about late 2020. This court had already reviewed an appeal on this case at that time. And by the time we had gotten there, Mr. Smith had refused to disclose anything within the fact discovery period, refused to disclose anything within the expert discovery period. But more importantly, he had refused to comply with any discovery requests. And that discovery request issue, while I realize is part of the sanctions issue, is informative of why the court felt that Mr. Smith, his failure to identify himself as a potential witness in his case in chief, in his disclosures, resulted in the trial court electing to exclude Mr. Smith and all of his testimony. Now, the court is aware that while in the reply, we see many references to declarations that Mr. Smith may have put before the court in relation to the TRO and a few other issues. In opposition to the material facts in a summary judgment motion, the evidence must be evidence that would otherwise be admissible at trial. That's established law under the state of Utah's rubric. None of those.
There's not really a distinction between the old evidence and the new evidence. If we're going to trial, it either all comes in or it all stays out.
Correct, Your Honor.
How was it harmful to not have it disclosed that Mr. Smith would be a witness?
Well, Your Honor, I think I would refer the court to De La Cruz, et cetera. And Judge Harris has a concurrence in De La Cruz that discusses the severity of 26D4 and how it impacts these issues. But the reality is that harmlessness issue is not ours. We don't bear the burden of harmlessness or prejudice. That isn't the case. But we made the argument that it was harmful and that it did prejudice us, that we had no idea what Mr. Smith intended to
So what's the
testify.
argument that you made?
We made the argument in our summary judgment motion, Your Honor, and if you give me a second, I will pull it up in terms of what that argument was, so that you can have the benefit of that.
Yeah, and while you're looking at that, help me understand how you didn't have any idea what he was going to say. If you already had in your possession the very declarations that are at issue now.
Well, the declarations didn't necessarily go to the causes of actions that were raised in our complaint, Your Honor. The declarations related to TRO.
Okay, but why is it harmful to you for them to, for Mr. Smith to use those declarations in this context now?
Well, Your Honor, it comes back to whether or not Mr. Smith would be permitted to testify. If he's not going to be permitted to testify, his declarations don't come in.
Well, true, but the question at hand is, how is it harmful for you? You said you had no idea what he was going to testify to. You said that literally 2 minutes
I
ago
did, Your
from
Honor.
this podium. And I'm questioning how you can not know what he's going to testify to if you have in your hand the very declarations that Mr. Boer wants to be considered now.
Because Mr. Smith's testimony changed over time. We weren't certain exactly where he was going to end up.
You know,
Well,
how
regardless
did
of
you know it changed over time if you didn't know what he was going to say, right? You have all of those declarations, right?
We do have those declarations, Your Honor, yes. I'm not going to suggest that we don't. And the reality is none of those necessarily are squarely on point. The crux of what it appears to be the argument on appeal is related to his prior breach argument, that he argues that salary and distributions somehow are the same thing. Well, the court knows that salary and distributions are terms of art. They're defined and they are not the same thing. The court also is aware that the shareholder agreement, and Judge Lucy, you engaged in this colloquy with Mr. Boer, makes very clear that distributions 2.05 are pro rata. Salary is something that the majority of the shareholders can determine as to each shareholder.
Before we get into that, I want to come back, though,
Yeah,
to
I'm-
this prejudice question.
I'm still wondering
was
how any
your-
of this shows harm on your part. and I
How
think
was
that's the
your
same question.
ability, how was your ability to litigate this case prejudiced by Mr. Smith's failure to identify himself as a witness? How did that prejudice your ability to litigate this case?
Well, the underlying purpose of that disclosure is very clear, and that allows, and this goes back to Johansson, for the parties to seek discovery from the party who has been identified.
So why did you not know that Mr. Smith maybe should have been deposed, or that he might
We sought
be
discovery.
called at trial without him telling you?
Your Honor, we sought extensive discovery from Mr. Smith. Mr. Smith refused to comply with that discovery. He refused to comply with a court order directing him to comply with that discovery. We got nothing from Mr. Smith, nothing at all of substance.
Well, his failure to comply with his discovery obligations might well be sanctionable, but that seems like a matter separate and apart from his failure to disclose himself as a witness, which is the behavior that got sanctioned here.
Correct. I'm simply explaining the purpose of the disclosure and back to where the prejudice is. If the purpose of the disclosure is to allow a party to then do discovery to determine what someone is going to say, what their testimony is, and how they're going to support it, and then that party refuses to comply with the discovery obligations, then the entire purpose of disclosures is undermined. Simply identifying yourself and then refusing to participate means that there is no use to disclosures at all. At that point, we can simply engage in trial by ambush, if that's what is going to be permitted under those
I
circumstances.
mean, it'd be one thing if you could stand here and say, well, what he wants to say at trial is different than what he said in those declarations, and you know, he didn't disclose a fact or a document or something that, you know, you could say, I'm going to be genuinely surprised by anything different than those declarations. But if he's limited just to being able to testify consistently with those declarations that you had, I'm still struggling with how that results in any harm or prejudice to you.
I think that's a different question, Your Honor. If it's limited to the consistent with the prior testimony, that's a different question than how we may have been prejudiced, because I don't know what he would testify to at trial. He's not given us that opportunity. We've not had that cooperation. And so from the perspective of prejudice and harmlessness, given that he refused to comply with that particular duty, I'm attempting to answer your question, Your Honor. That really is where that lies. And if that's not sufficient, I certainly understand that. But that's the explanation that I have.
Can you talk to us a little bit about this case in front of Judge Renstrom where your co-counsel signed a pleading calling this very argument you're making specious and absurd?
Sure, Your Honor, and I reflected the court's 43 cases over the past 10 years that made clear that each individual judge is entitled to make their own decisions and to exercise their own discretion. Judge Renstrom exercised his discretion in that particular case. It's my job to make arguments in different cases. They may be different arguments in different courtrooms, but it's my job to make the argument. It happened that Judge Renstrom agreed with us. He exercised his discretion to determine that our clients were going to be able to testify. Had he done otherwise, I don't think, had I appealed that to this court, you would have found any abuse of discretion. The case law makes that pretty clear. I can find one case, Johansson v. Johansson, in which this court reversed the trial court's determinations related to whether or not to exclude a witness. Otherwise, every other case, without exception, simply says the trial court did not abuse its discretion in its disclosures, in whether or not to exclude somebody for damages or witnesses or documents. So from that perspective, I don't think I think that's a red herring. What Judge Renstrom happened to do in a case that we happen to be involved in with similar parties is not relevant to the question for the court here, and whether or not Judge Maynard abused his discretion in making a determination that Mr. Smith, in failing to disclose himself, and the history of the case thereafter, should have been excluded. I don't think the two overlap, in other words, if that makes sense.
I have a question about the shareholder agreement and this, whether distributions include salaries. Respond, please, to the argument about course of performance, that for years, it sounds like, everyone received the same distribution, or the same dividend, the same health insurance, the same salary, that the agreement was interpreted in practice as everybody gets the same share of all of that.
Well, I don't think there's any evidence one way or another on that particular issue that's before the court, first of all. But secondly, at no point in time, whether or not the shareholders elected to operate under 2.06 to change salaries, did they elect to obviate or eliminate 2.06? At some point in time, they came to the conclusion that 2.06 should be something that they elected to apply, and they made a determination, a majority of the shareholders, which is consistent with Utah law, to vary the salary on production for each of the individual shareholders. Now, whether or not Mr. Smith liked that isn't material. He voted against it. He was entitled to do that. But at no point in time was 2.06 written out. At no point in time was there any discussion that I'm aware of that wasn't something that they were capable of doing. The fact that up until that point in time, they may have, in the previous 6 or 7 years, not changed salaries for the parties doesn't change that. It doesn't amend the document simply by the fact that they haven't done something. There are no affirmative minutes that I'm aware of, and Mr. Smith didn't produce any. There are no affirmative statements from anyone, and Mr. Smith didn't produce any, that would suggest that they agreed on writing it out or amending it over, or that distributions would include salary.
Is that supposed 6 or 7 year history part of the summary judgment record? Do you recall? I
No,
haven't
Your Honor,
looked at-
it's not. That I can say categorically. It's simply not part of the record because it wasn't something that was ever discussed. There was a discussion within the summary judgment about distributions, what those were as a term of art, how that was defined, and salary, which are distinctive under the IRS code, under Utah's LLC Act, and elsewhere. There is no place that we were able to identify that would suggest that there's some overlap between the two. It doesn't exist. I have one more point, if you'd let me.
We
just
let
in
the
terms-
other side, we'll let you as well.
Just in terms of the sanctions piece and whether or not there's any authority related to striking of third-party complaints. And I think we cited to this in our briefing. It's Payne v. Exxon Corporation, 121 F. 3rd, 503. In reply, Mr. Smith suggests that that case does not support what we're saying. But if the court were to read it, and I can read from this case to show that it is precisely on point here. Payne v. Exxon Corporation, Coronado v. National Default Servicing Corporation, which is a Ninth Circuit case. There's a 10th Circuit case, FDIC v. Daly. There are multiple cases that basically have adopted Payne v. Exxon Corporation's analysis. And what Payne v. Exxon Corp says, rather Lowe, and this is on page 509, rather Lowe argues that the district court lacked authority to dismiss the VICO claim because the discovery requested issues were propounded by Exxon. Federal Rule of Civil Procedure 37A2A provides that any other party may move to compel the automatic disclosures required of all
Yeah,
litigants.
but didn't that case turn on who moved, not who made the discovery request?
It turned on, in part on that, Your Honor, yes.
Yeah, so Mr. Brewer's position is it doesn't matter who made the discovery request. What matters is who moves for sanctions. And what he's saying is across the country, there isn't any case where someone who didn't move for sanctions got sanctions. I get what you're saying is that in that case, the discovery request was made by one party and the motion for sanction was made by maybe some other parties. But I don't think that's the situation here, is it?
Well, no, Your Honor, because VICO had made an earlier motion, but they didn't join in this motion. The motion that resulted in this striking, at least not through my reading of this case.
But weren't both motions asking for the same thing?
No, not that I'm aware of. Lowe correctly asserts that VICO would not have standing to move to compel answers of Exxon's request. The sanctions provided under Rule 37B2 contain no such standing limitations. Then it recites Rule 37B2. The scope of sanctions for failure to comply with a discovery order is committed to the sound discretion of the trial court. If Congress had intended to limit the district court's dismissal authority to claims against the party who propounded discovery, it would not have chosen such sweeping language. Rule 37B2, plaintiff's willful and repeated violations of discovery orders gave the district court authority to dismiss the entire action or proceeding. That's what it says. I don't see anything in here that suggests that VICO was directly involved in that. VICO simply got the benefit of the entire action or proceeding being dismissed. It was a third-party plaintiff, apparently, or third-party defendant, but it got the benefit. So to suggest that there's not authority that supports that, Payne v. Exxon Corporation does support, at least in my reading, the decision of the trial court to strike the third-party complaint. And on top of that, Your Honor, we made this argument in our brief, there is no third-party complaint. There are affirmative requests and a counterclaim. Breach of contract, breach of good faith and fair dealing, and fiduciary duty.
And I appreciate you making this point, actually, in citing Judge Orm's case, where he specifically wanted to teach bench and bar about the difference between Rule 14 and Rule 13H. And you're absolutely right about that. But that doesn't mean it's improperly pled. It just means it's not a Rule 14 pass-through liability claim, right?
Correct, Your Honor.
They can still do it. They just have to do it under 13H, not 14, right? Or 13G, whatever the subsection is.
That may be the case, Your Honor, but they have to bring in the parties.
So, I mean, that's kind of neither here nor there, but it was fun for me
All
to
I'm
watch
saying
you
is
say
it's not
that.
really a third-party complaint. And if
Yeah, it's a counterclaim to which they added additional parties pursuant to Rule 18 and Rule 13G.
one could certainly stretch to make that argument, yes, Your Honor. I think that it requires several steps that weren't taken.
I'm not sure it's much of a stretch.
No, they're just calling it the wrong thing. It's not that it's improper.
And I can't argue that, Your Honor. At some point, you could probably make those claims. The calling it a third-party complaint is, and striking a third-party complaint. If it's a counterclaim pursuant to the analysis that you just set forth, then dismissing the counterclaim is dismissing the counterclaim.
Well, they made a counterclaim back against CMP, and then they added additional parties to that counterclaim pursuant to the provision of Rule 13 that allows you to do that.
Correct, Your Honor.
Nothing to do with Rule 14. You're right about that. But
And
that
I'm not
doesn't
arguing
mean-
that point.
But that doesn't mean it's improper.
Yeah, and I'm not arguing that point, Your Honor. I'm just saying if the district court struck the counterclaim as a sanction, it struck the counterclaim, which makes the argument concerning the third-party complaint really
Other than
irrelevant.
insofar as it struck the counterclaim as
Because
asserted against
CMP.
counterclaim defendants
Yeah.
who had not asked for that relief, Mr. Brewer's point seems still valid, even if it's not truly a third-party complaint.
And I suppose it could be, Your Honor, but the court certainly has the discretion to strike the action against all parties. I think that the rules are relatively clear about that. Court have any other questions?
It doesn't look like.
Counterclaim defendants, not to overuse the term, end up being third-party beneficiaries of the relief to which other parties were entitled.
I suppose that would be a good description, Your Honor, yes.
Thank you.
Thank you, Your Honor.
Mr. Brewer.
I know you're going to get there, but can you start with the Ninth Circuit case, Payne?
Yeah, I mean, Payne on page 506, Baco joined Exxon's motion to dismiss, which is why dismissal as to both of those parties was appropriate.
Did both parties move for relief in that case?
Yeah.
And did they
Baco
move for the
joined-
same relief?
Yeah, they joined Exxon's motion to dismiss. If you look at page 506, that's what happened. So, and even if it isn't what happened, it would be the outlier of all outliers. I mean, this court has said in Bailey that our Rule 37 is not self-executing, so you're going to need someone to file that motion, and we think it's inappropriate here. 3 quick points on each of the issues. I may have actually hit the last one already. The list of clients under the covenants, under the employment agreement, it goes back 1 year. I think it goes back 5 years, but it's 5 years going backwards from July 31st. That's the list that's important for breach of the covenant. That is not the list that's the same list as of December, assuming that that is the operative date, and it's the earliest that it could possibly be. I also
Why would it not be the earlier date in, was it April when he gets?
Mr. Smith was terminated July of 2014. CMP is now taking the position that that is also when the discreditable acts were declared
vote
and the
happened.
option. But if you look at Addendum G to the brief at Exhibit 3, is a letter from CMP dated December 12th, 2014. It says, with reluctance, the partners have concluded that you have engaged in a discreditable act, and we are
So that
exercising our
did not happen
purchase.
at the same time
That's
as
right.
the termination.
Absolutely not. And the lists are different lists because they cover different time periods, and they have to be. Otherwise, if you breach the implied, or if you breach the covenant not to compete, then all of a sudden there'd be liquidated damages, plus you'd forfeit your shares for nothing, for the exact same act. I mean, that isn't the right way to interpret this, and you don't need to because the dates were farther apart here. We're looking at December, and we're looking at a completely different list. We don't go back 5 years. We is the date of December. Page 11 of the motion for summary judgment, that's where you look for the harmfulness discussion that counsel was pointing you to. All it says is that it was harmful, and then it says, it was not harmful, and then it says it's not harmful because sanctions conduct can never be harmless. They're talking about the discovery, the failure to produce that was already sanctioned. That can't be, it wasn't that they moved for now we want an additional sanction for the exact same conduct, which includes exclusion of this declaration. I also want to point out that we do have declarations coming in 2017, 2016, 2021. Those are just 3 of them, not to mention what's going on in the consolidated case. There are cases that are consolidated with disclosures. The pro rata, they said there's no evidence of the course of performance. Look at 1450 through 55 of the record. And what does it say? It talks about distributions 2006 through 2012. Some types of distribution did not appear in the reconciliation because it was the practice for years that these were paid equally. This includes salaries from CMP to shareholders, dividends to shareholders, salaries of spouses were put in the formula to make sure it all came out equal, distributions, even though they were indirect. And so there's absolutely evidence of this course of performance. We would ask the court to reverse the sanction as to any claims with regard to the individual shareholders, and only the counterclaim directed at CMP remains stricken. We would ask the court to reverse the striking of Dan Smith's declaration. Based upon that declaration, the court can either send it back down to revisit the summary judgment, or can look at the prior breaches that are articulated in the declaration and say, this summary judgment should be vacated and the court and the parties just need to go forward marching towards trial. We would also ask the court to reverse the finding that was put in the order for the first time that CMP has already purchased the shares for $0. And to say they may be entitled to repurchase them. They certainly gave notice of exercising the right in December of 2014, but they've never generated a client list, let alone a client list that they've shown on the record that Dan Smith then subsequently violated to forfeit his right to be paid for those shares. And therefore, we ask the court to reverse all of those and send those back down for reconsideration. Thank you, Your Honor.
Thank you. Thank you all for your briefing and your argument today. These are difficult matters. We'll take them under advisement and get out a written opinion as soon as we can. And we'll now be in recess.